My name is Robert Tepper. I am a lawyer. I am also a mediator. I've been practicing law for approximately 43 years. I've also been involved in mediation for approximately 30 years. We're going to speak today about what a lawyer... So therefore, what we're going to talk about today will be mediation other than a typical divorce mediation. Mediation can do very spectacular things for a dispute in the right case and under the right circumstances. It can save an awful lot of time and money, can save the expense of preparing for a trial, trying a case. It can also produce a lasting agreement. Sometimes, if there is an agreement that is reached outside of mediation, the minute the ink dries, the parties are looking for a way to get out of the agreement. They feel resentment about the agreement. Mediation tends to produce agreements that the parties are happy about, and therefore agreements that last without further controversy. In a mediation, the parties create their own resolution. They decide what the result will be. Nobody makes the decision for them. No one can go to a mediation and end up with something with which he does not agree. So because of that, I usually let the other side pick the mediator. But in any event, we had a recently retired judge, and he started perfectly conventionally with a joint session, broke up the parties, and then after a very brief period of time, the mediator couldn't stand it anymore, and he said, okay, I'm going to tell you what I think this case should settle for. I'm going to tell you what it's worth. And the mediator came out with a number that both sides didn't like, because neither side had been involved in the mediation long enough to shift his position back towards the middle. The parties were still in their original standoff positions. So as soon as the mediator did that, both sides said no, and the mediator said, okay, you don't want my opinion, goodbye, and that was the end of the mediation. So having an evaluation can be a big negative. A good mediator will be careful about evaluation, will be reluctant to give an evaluation, and will wait to give an evaluation, and will give an evaluation with lots of weasel words, maybe, probably, if everything comes out right, possibly, things like that, to leave himself some room. Okay, so we spoke about encouragement of good tactics. Another thing that a mediator can do, and a good mediator often does do, is what's called reality testing. Parties come into a mediation with their own idea. The plaintiff thinks, I'm going to win this case. I know it. I have a good case. The defendant obviously thinks the opposite. So the mediator can ask some questions. The mediator doesn't need to say anything. The mediator just needs to ask questions. Well, what will happen if the case doesn't settle? Okay, so you're going to try the case. How long will it take to get ready for the trial? How much of your time are you going to have to devote to helping your lawyer prepare to try this case? How much is it going to cost you to try the case? All of those deposition transcripts, how much are they going to cost? Do you think you'll need an expert in the case? What do you think an expert typically charges? Notice the mediator is asking questions. The mediator is bringing out the views, the knowledge of the party, rather than saying, let me tell you what the case is going to cost. The mediator then goes on, okay, what's going to be the outcome of the trial? And if you win the trial, do you think the other side will appeal? And if the other side will appeal, what's